Misco Health Law, bringing you yet another installment of Cairo Secure's Growth Without Risk series. And today we're going to talk about post-payment audits, but what happens at the end in most cases, interestingly enough, is not litigation, it's not arbitration, although it can, but in 98%, 99% of cases, post-payment audits that are brought forward by a commercial payer against a provider are resolved in some form of settlement. Now, the reason I talk about this is if there is a negotiated settlement, that's how they usually end, and that's fine. The concern comes up, and I had a case recently where the appeal resulted in a huge move in the actual overpayment amount, rescission of the statistical sampling, the projected portion of the overpayment, leaving a rather minimal payment amount at the end. And the doc, of course, was thrilled and ready to write a check and get out of this thing. Nonetheless, we continued to push towards not only rejection of some of the things that remained wrong in the actual overpayment amount, but we did so not because of the money, but for the value of having a negotiated settlement at the end of the as a way of terminating or concluding the case. Now, if the doc would have wrote the check, certainly the liability and the issue as it related to the specific claims that were at issue in the audit would have been resolved. However, it would have resolved nothing else, and it would have left, there was a requirement to sign a very generic corrective action plan, which the doctor could have done, but looking forward to how that might have turned out in a subsequent audit and how that would have been interpreted, leaves some question and leaves some liability that you don't want to go forward with those issues being unanswered. So in that particular case, as I would in any case, we're going to continue to drive towards an actual settlement amount with a settlement agreement that contains some necessary terms that will protect the provider going forward. Now, the value of an agreement is just like your provider agreement. This is an agreement between you and the payer to resolve issues regarding this particular audit. Now, every settlement agreement, there's no admission of liability, even if you're going to make a payment. The non-admission of any liability by any party is critical. If you just write the check and pay them back, then there's a presumption that you are wrong. The beauty of a settlement agreement is we disclaim any agreement as to the accuracy of the substantive findings by the payer in the audit. There may be some stuff for purposes of settlement that we will concede, subject to the Federal Rule of Evidence 408, which means if we concede it in settlement, they can't use that concession later should the settlement not occur and we proceed to an arbitration. They can't say, oh, well, you conceded this or you conceded that. When you concede subject to the rule, they cannot bring those concessions up should the settlement negotiations fail. So one of the bonuses of a settlement agreement is it gives you the ability to negotiate in good faith, make concessions for purposes of reaching an amount that you can both agree to without ever having to admit that you actually ever did anything wrong. And it's you've probably heard this, but a good settlement angers both parties equally, meaning that neither party gets what it wants. The doctor pays more than he or she thinks they should. The payer gets less than what they think they're entitled to. And in some cases, way less. And depending on the issues and both the legal and the substantive issues that are raised in the appeal, as well as the doctor's attitude towards corrective action, things that you do during the pendency of the audit to address some of the areas of larger concern. All of those things factor into the ultimate settlement amount, which we're not here really to talk about. But it leads us to the position where we're going to create a new bargain, meaning we're going to make an agreement about what each side is going to do. And one of the things that the provider is going to have to do is probably cut loose with some money. And as I mentioned, it may be more than what they technically owe, or than what's proven, but it should be an amount that's at least equitable under the circumstances. In most cases where there's audits for a reason. Usually there's a billing pattern or something that indicates that the provider was paid for something that should not have been paid for. And if that is objectively true, then certainly the value of those services, subject to look-back limitations and things of that nature, are going to come into play in terms of valuing the settlement. But we're going to have a defined amount, so we don't have the uncertainty of what it's going to cost to get out of the issue, and there's benefit to that. Usually it is an amount that it may sting a little bit, but the doctor can afford it. And where there's significant liability, it usually represents the limit of what they can afford. When the amount is small and the amount really isn't at issue, that becomes a lesser concern in the settlement agreement, but we still want an agreed amount because it becomes the linchpin for some other things that we want to put in the agreement to protect the doctor. And one of those things, beyond the repayment amount, is the mutual covenants, if you will. So there's covenants regarding non-disclosure. So the payer, neither the payer nor the provider can disclose the details of the settlement agreement, except potentially to like attorneys, accountants, things of that nature, that are necessary for their business operations. If it's the Blues, they may need to disclose to OPM consistent with any legal obligations they have to disclose. You cannot shield disclosure from the government, but you can preclude the payer from volunteering. So it would have to come based upon a demand for that information from the government. And usually it would be from somebody like the Office of Personnel Management, who administers the Federal Employee Health Benefits Act. Where there are FEBA claims or FEBA plans at issue, they're certainly going to be involved in that process and have to know about the settlement. Beyond confidentiality, the big piece is mutual releases. And as I mentioned, when the amount is small and you write the check, it's only going to be about the claims that were in the sample of claims that they audited. It's not going to be about anything else. And usually a doc wants to end one of these situations with the knowledge that that's all there's going to be for that time frame. So whatever the date of service range was for the audit, and certainly potentially whatever codes were at issue, the doc doesn't want them coming back and dipping into that same bucket again. So what we draft in the agreement is what are called mutual releases. So if the doctor has any claims that are in that time frame, the doctor is giving up any right to go collect on that money, reprocess claims, resubmit, whatever. So the doctor's boxed out of that entire period, but then so again is the payer. So what we want to do is we want to limit our liability for any issue for the claims in a particular date range, or whatever the date range was of the audit, to the amount that we're going to settle for. So the doctor's giving up any unpaid claims that he or she has in that period. Similarly, the payer is giving up any claims they may have on any other issue. Now, I try to write those releases somewhat broad, all claims within the date range, under the premise that the payer had the ability to look at whatever they wanted in that date range, that they chose only certain codes, that wasn't that wasn't a limitation that we imposed, and therefore I try to get them to agree that all claims, all codes, anything within that date range is within the scope of the release. Sometimes they push back, and sometimes explaining to them, look, do you really anticipate going back there, or are you just being picky about the language? And if you don't really anticipate going back there, what is it? What do you really? You're not giving up anything. So from that perspective, that becomes a very important provision. The last thing that I think is important is the corrective action. Be very, very cautious, because sometimes payers will send a document indicating corrective action that the provider has to agree to, when you're paying back the money. And sometimes those are not as precisely drafted as they should be. If we're going to submit a corrective action plan, usually we're only going to submit corrective action for things that were actual violations of the existing agreement and or incorporated medical policies. Unfortunately, in post-payment review, payers have a habit of imposing requirements post hoc, meaning after the fact, in that an auditor citing the what I like to call the everybody knows statute that not everybody knows about and no one can actually find it. But their perception of what records should look like, what records should have, and those things are external to the actual policy manual, and that usually would be part of our appeal, of course. Pushing back that those didn't justify overpayments, even if they did, or even if they were wrong, they didn't justify overpayments because it's not a condition of payment. Instead, it's a condition of participation. But leading up to the settlement, those are the arguments that we make to kind of diminish their expectation in the solidity of their position. Nonetheless, when it comes to the corrective action plan, they like to bury that stuff in there, and you need to be careful for two reasons. One, the question arises, does the corrective action plan operate to modify your provider agreement and or their medical policies? And in theory, it could, especially if it was perceived that way. It was written after the medical policy. It was after an audit where the policies were at issue and the payer is clarifying. You may be the only doc stuck to that interpretation of the medical policies, and therefore you have to be careful of the language in a proposed corrective action plan to verify that it doesn't actually modify your obligations under the contract or any incorporated medical, reimbursement, or coding policies. The second thing is that you want to limit the corrective action to only the things that were actually wrong. Whether, the beauty of settlement is that we don't agree that anything was wrong, but nonetheless, giving the payer their due, for the things that we conceded for purposes of settlement, it would be appropriate to write corrective action there, but make sure that it's something you're actually going to implement and do. The worst thing in the world, because providers don't believe this will happen, but it does, it can and it does, is that they do a settlement, they dodge a big bullet, Mike, you're the greatest lawyer in the world, and we do this corrective action, and then they don't implement the corrective action. And you try to follow up and say, hey, let's look at some charts, and the doc's too busy, and they think that they've dodged the bullet, and that bullet isn't going to come around and smack them in the head. And then 6-8 months later, then the payer actually either pulls some records randomly to validate the corrective action, or they see the billing profile moving back in a direction that caused the audit in the first place. And when you get audited the second time and you did not implement the corrective action that you said you would, that second audit and the settlement and the resolution of that second audit is not going to go as well as the first. So be mindful of that, that you have assistance drafting that, making sure you understand what you're obligated to do, and you actually diligently implement that stuff going forward, so that you don't run into that scenario. But for reasons of mutual releases, confidentiality, and control over the corrective action plan, you should always seek to resolve any post-payment issue where they've audited charts and they're asking for money back with a settlement agreement, to the extent that you don't, you're not forced into arbitration or something like that, and then the arbitrators, or if it's into court, that the court's going to handle it and it's going to be a right or wrong issue. But for cases that resolve, or the amount goes down to something you think it's just easier to write the check, think twice, because yes, it may be easier to write the check, but you may not have the protection that you want on the back side of that. So therefore, sometimes, and I don't say this out of self-interest, in that it gives me more to do because I don't need any more to do, and most attorneys don't either. But it's really out of a desire to get that agreement in place so that you're protected going forward. I hope that's helpful. Next week, Dr. Sam Collins is going to be up talking about some fascinating stuff, I am sure. And until I see you next time, everybody have a great rest of your day.